Hello, everyone. Welcome to today's webinar, COVID-19 International Employment and Operational Considerations. My name is Talon Johnson, and I am going to be hosting the webinar on behalf of Global Upside. And just to go over a few housekeeping items before we get started with the actual webinar. We are recording the webinar, and we'll be providing both the recording and a copy of the slide deck to you upon completion of the webinar via email. And we do want to encourage you to send us any questions that you have throughout the webinar via our chat window at any time that you have them. Our panelists will work to answer any questions that you have during our Q&A, which will be at the end of the webinar. So again, feel free to send in any questions that you have. And additionally, please feel free to share any comments, feedback, and questions that you have with marketing@globalupside.com. It's now my pleasure to introduce our panelists to the webinar. So first, I'd like to introduce Andrew Wilson, who is the VP of Private Equity and M&A at Global Upside. Andrew is an English chartered accountant and has extensive international experience working in London, Lagos, Nigeria, Caracas, Venezuela, and San Francisco with PricewaterhouseCoopers. He worked at Oracle, establishing their first 25 international subsidiaries. He spent 10 years as a CFO with public and private companies in charge of finance, human resources, payroll, and benefits. During that time, he built 4 international networks. At Global Upside, he has led engagements in electronics, manufacturing, and software that involve the Big 4 accounting firms and several international law firms. His areas of expertise include international employment law, human resources, payroll and benefits, finance, and operations support. Next, it's my pleasure to introduce Kim Sanderson. She's the Director of Human Resources at Global Upside. Kim possesses considerable experience in international HR. In previous roles, she has worked as part of internal international HR teams as well as in HR advisory functions. While working with Tesla, she helped rapidly expand their European operations. She applies this experience when partnering with Bay Area companies to assist with global expansion and merger and acquisition activities. Her area of expertise is EMEA employment law. She also specializes in acquired rights and contract standardization. It's now my pleasure to pass the time over to Andrew and Kim.
Thank you, everyone, and thank you for sharing this experience with us today. Obviously, a difficult period of time for everyone, and our thoughts and prayers to go out to obviously the sick and the recently passed doctors, nurses, and first-time responders. And this webinar is meant to really address some of the practical issues that are going on during these difficult times as we consider how to react to COVID-19 and what is going on in the world at the moment. So very much this is somewhat European focused because they're obviously led the situation in terms of responding to COVID-19 and its effects on businesses and employment in terms of putting in safety nets and what's going on in the world. And they have a lot of the infrastructure in place as well as in South America with the existing social safety nets to support this. In terms, obviously, of sick pay and really responding in those particular aspects of it, there is extensive support schemes in place already in terms of providing for full sick pay during these periods of time and supporting workers as they are taken ill and forced to take time off from work. These have been changed as we have gone through this crisis in terms of the fact that they have accelerated a lot of the waiting periods in terms of previously there had been anything from 3 days to 10 days waiting period for these to take effect, and a lot of the governments have basically said you can apply and receive immediately sick pay in terms of what can be provided to support you during this time. There's also the concept of preventative leave or sick pay that's been introduced, where people who are elderly, certain age groups, as well as pregnant women, are entitled to take leaves of work, and if that forces them into a situation that they can't work from home and telecommute, then they are also entitled to full sick pay during those periods of time. The other aspect that is very prevalent in Europe and really came out of the 2008 financial shock and its effect on businesses that basically were forced to lay off workers for temporary periods of time, which could be extensive, was introduced in Germany during that time, where they have a concept of short-time work. In the US, you might consider this to be more associated with furloughs or temporary layoffs. And it's very much a scheme which accommodates trying to maintain employment during these periods of time where people are being forced to have substantially reduced time in terms of working or maybe totally laid off during these periods of time. And the short-term work schemes are very much regulated. They have extensive rules. They are situations where companies cannot unilaterally put in place this short-time work or these furloughs. There is a whole regulations around it, and you do have to apply to the government in terms of what you can do. You can get approved, and the governments have schemes in place where they will reimburse you for specific employees if you can prove that there is considerable loss of hours and the operational requirements as well as the personal requirements have been met. And it is something where you do have to apply to the government and get approval for in terms of the reimbursement. The reimbursements can vary from anything from 70% of the employment up to 100% in certain countries like Norway and Sweden, where they've implemented schemes that can provide that 90 to 100% of employment. It does have to be obviously a substantial loss of time during these periods. So that's why governments are talking about reimbursing anything from 70 to 80%. So obviously you're talking about going deeper into the time that these employees can work for you during that time. And it does have to apply to a portion of the substantial portion of the workforce. And there are different rules out there about what represents a substantial portion. It does not have to apply to all employees. So you are in a situation where if you have essential workers that need to continue to work during this period, but you want to lay off other people, then certainly that type of scheme can be put in place. And then obviously companies are talking about vacation, PTO, RTT, entitlements where employees do have accumulated PTO vacation time and forcing them to take that off during this period in exchange for continuing the employment. But obviously the emphasis is that it is something that has to be mutually agreed with the employees. You cannot unilaterally enforce it. Many of the European and South American countries do have extensive unemployment pay and benefit schemes. These, again, have been accelerated by the local governments in terms of the entitlements and the waiting periods. And so there are provisions in place to provide that. But I think in terms of the overall gist of this is that what the governments are trying to do is obviously to try and maintain employment wherever possible, recognizing that this will pass and this will be a situation which is temporary, and they hope that everything will come back to put those people back to full-time employment as soon as possible. So the thing to remember in all of this is that there are what really the European governments and what the South American governments are starting to do is really modify existing programs and put more programs in place, and they are coming out with small business loans and additional assistance to try and make sure that companies survive during this period, recognizing that there's going to be a cash crunch. And the emphasis in all cases is trying to maintain employment and put things in place. So really, it's all about retention measures, even if you do have to reduce people's time or lay them off completely temporarily. But it is heavily regulated. To qualify for the government assistance, you really have to make sure that you follow due process, you follow notifications to the employees of what's being done. You do have to meet the operational requirements, and you do have to apply for the government agencies. They have discussed accelerating what's going on in terms of the providing you confirmation that you will be entitled to the reimbursement for these short-time work, or as they call it in France, partial activity periods. But really the emphasis right now is that you do have to apply, you do have to get approval, you do have to have met the requirements, and that really it's all about trying to maintain their ongoing employment, and it is temporary in all cases. We will be discussing a little bit about border closures and immigration during the seminar as well. And really, a lot of it is around the fact that if you are in the country and you have work permits, visas, and are entitled to work in the country, then right now, the emphasis is that you can stay in the country, and a lot of the immigration authorities are moving to extend the period of time and without having to apply for the extension, recognizing that a lot of the government departments that normally do this are in place. It is unfortunate if you're outside of the country that border closures and preventative measures are being put in place. A lot to do with which countries you might have been present in prior to wanting to come home. And in those situations, they are being very strict in terms of what's going on. So I think overall that's kind of at least an introduction here, high-level summary. Kim, did you have any additional comments?
Hi, Andrew. My main comment at the moment is essentially just schemes are being implemented and changing constantly. The UK scheme, for instance, was announced as going live at the beginning of April for applications, and it has already stated that it will be pushed to the end of April. So I think with one thing just to bear in mind with this is things are changing rapidly, and this webinar will be very much a snapshot in time of what we know at this moment in time to try and give as much guidance and assistance and support as we can.
Okay, next slide, Karen.
So I'm now going to talk around a little bit more in regards to temporary layoffs, short-term work, and the government support. I think the main thing that I would kind of like to make clear with this is temporary layoffs in the US are a lot simpler. I know not all of our clients are US based, but I know predominantly they are. And I know you're used to working with an at-will employment model. As you'll have been aware when we've been setting stuff up, the notice periods, etc., that you have in Europe, they don't necessarily permit temporary layoffs. Now, some countries are putting in place legislation that will perhaps permit that, but again, that is all subject to change. And I think my advice to anyone who is even considering this is to reach out and speak to us about it. The employees don't have to actually agree to this. Whilst a company can be in dire financial difficulties and may even be saying to us, you know, we don't know how we're going to be able to pay our April or May salaries. That doesn't actually in Europe on the whole give you the right to suspend payments. It's all going to have to be mutually negotiated and agreed. What I will say though is Europe is under the same sort of lockdown that is happening in many places, and people are, generally very aware of the impact, and trying to work with their employers to actually get through this and realize that there will be light at the end of the tunnel. The sick pay provisions that are being modified. So Andrew referred to this briefly just now. So UK, for example, the waiting period for statutory sick pay has been removed. Statutory sick pay is not a huge amount. It's less than £100 a week. But these are all small concessions that governments are doing, not just here, but in other countries, in order to try and support. The parts to discuss in regards to how layoffs work, it's very difficult to cover this, because in so many countries it isn't, okay, we can do this straight away. So even if you were to look at reducing someone's salary or, applying for any of the government schemes, then we would hope that you are much more thinking along the lines of, how long will this actually last and what support is there? I would say, having looked at the government schemes that are published, the initial support is available essentially for 3 months, which would cover the majority of the lockdown. Again, as Andrew said, the applications to make use of these schemes, a lot of the details are still not yet as public, still have not been published. But I think what I've seen so far will be very much along the lines of, you will have to demonstrate, if you are applying for government assistance in regards to financial support in order to meet your salary and actual payroll requirements, then you would need to demonstrate that the employees have been legally furloughed, that they have agreed to this, and if that country permits it, or whether you're looking at other sort of temporary variations. There's obviously a number of other impacts in regards to the fact that schools are closed in many countries, as they are in the US. People might actually be unable to work at the moment due to the fact that they have their children at home. That obviously leads to a little bit more of a difficult situation. And I think my guidance on that is very much along the lines of, the entire world is in this boat and it's working how best to support. Now, whether that would mean that, people are moving their hours around, working around childcare, trying to do their homeschooling. I think essentially my message in this is, the only way to get through any employment legislation in Europe is very much a case of, we are in this together, not just from, a business perspective, but between employers and employees. It's going to be, not making very harsh or drastic decisions, and, not waiting, because I know that waiting isn't necessarily acceptable in some situations, or people might not have the cash flow, but realizing that, as Andrew said, that we're hoping that this situation is temporary, but trying to do what we can in the meantime. Do you have anything you want to comment on with that, Andrew?
Yeah, I think a couple of things. I think, as Kim's alluding to, in terms of the whole process, as we were discussing before, there are operational and personal requirements you have to meet. In Europe, you have to obviously consider also works councils and collective bargaining agreements, and also the provisions of the employment contracts you put in place with the employees. I think obviously when you come to South America and even over in Asia, you have to consider the union implications. So there are lots of different aspects to that perspective. And then again, I think that the preparedness of countries to be able to implement these schemes and actually start reimbursement processes does vary widely. As I said, Germany has had a fairly robust scheme in place since it was originally enacted in 2008, and it was well defined by 2011. But with their particular process, they guarantee a response of whether they're going to pay you the money within 48 hours, whereas right now, the UK scheme is still in process, and they are hoping to be able to have the scheme in place by the end of April. And then in terms of funding, obviously, I think as Kim has alluded to, if you're in cash flow situations and you're expecting this to start flowing straight away, much as here in America when we talk about the Regional Emergency Act that was put in place, that funds they're hoping will be available in 3 to 4 weeks. In these situations as well, you're really saying that when you can expect funds to really flow to you is going to be varying from country to country. And so they are agreeing if you get approval to provide this type of support, but it will take some time for you actually to receive the funds. So I think there's a lot of operational considerations here in terms of how you go about this. But as we'll discuss in the next section, I think that these operational considerations, can be a lot easier to deal with than some of the considerations if you are having to think beyond this in terms of saying that you really can't support your employees. So we'll definitely deal with that on the next slide. So really this goes back to a lot of the considerations internationally in terms of the extensive employment protections that are provided. And just to reiterate, the US is the only country really in the world that has this concept of at-will employment, and really you do not have to have really good cause for terminating anyone. Obviously, there's certain protections still in place in terms of the age of the employee or various aspects of whether they're pregnant or whether they have disabilities. There's specific protections for people like that, but otherwise, really, you can furlough workers and you can terminate workers without good cause. This is totally different internationally, where labor laws and statutory requirements are very much, are very robust, has a heavy emphasis on protecting the employees and making sure that their rights and terms and conditions of employment are respected by the company, and things are followed in due process in terms of those employment agreements. So, and in most countries, they do require that you have employment agreements with your employees. They do define very clearly what their entitlements and what the terms and conditions of their employment are, and often they define what they're entitled to in terms of the termination process and what goes on there. So really, as I said, it's at-will employment in the US. In most international countries, especially in Europe and in South America, there is this concept that you have to have good cause for terminating someone. So you have to have demonstrated that your cause for the termination and your documentation has all been put in place to make that happen. And of course, good cause varies. It's very different from country to country. But even with terminating for good cause, it does create entitlements to severance pay and notice periods. So immediately that you're employing someone internationally and you're entering into an employment agreement with that employee, they have vested rights. Now, these vested rights can be very dependent upon the type of contract that you enter into, which Kim is going to discuss in the next slide, in terms of why a lot of employees, particularly in Europe and South America are employed on temporary contracts rather than on fixed term or permanent contracts. But immediately upon entering into an employment agreement, rights start vesting to the employee. And in terms of those rights, that they have the entitlements to anything that's defined in the terms and conditions of the employment contract, as well as the labor laws, immediately you're into a situation where, as we discussed, you have to have good cause to really terminate anyone. So, really anything that you change in terms of the T's and C's, can create what they call constructive discharge. And what you might consider over here to be minor in terms of changing a terms and conditions of employment. So it may not be compensation. Obviously, we're talking right now about reducing people's compensation, forcing them to take vacation PTO, terminating their benefits for a period of time to save the company money. Anything that's changing their terms and conditions of employment can be considered willful misconduct. And in terms of being willful misconduct, you're saying that you're creating an environment, you're changing the terms and conditions that is forcing the employee to leave, and you're trying to force the employee to leave without being entitled to severance pay, notice period, and other benefits. And the thing to remember in all of this is that, again, it's not at-will employment like the US, and in some European countries in creating constructive discharge that entitles the employees to severance pay and notice periods, you can end up in situations that they have entitlements to months, if not years, of severance pay that is dictated through things like the employment agreement, through works councils, through collective bargaining agreements, as well as union entitlements that they may have. And then you do in South America in particular, you have a whole system of labor tribunals and courts that actually adjudicate in terms of what the entitlements are. And oftentimes, particularly in South America, but even in countries like Spain and Italy, you have to go through a process with the courts to make sure that the severance pay that you're paying out and the benefits and the notice periods that are being given are reasonable in terms of how the employment has been terminated. So very important to remember this in terms of anything you're planning to do, because these employees have rights, and you have to follow due process. In all cases, we recommend that, as Kim discussed, a mutually agreed negotiation with an employee, depending on how you go about it, is the best way to go. And I think the other thing to remember in all of this is that the less that you put in writing in terms of the process, which can be deemed to be varying the terms and conditions of employment, is the better from the perspective that it may be used in evidence against you. So again, really, the employment agreements modified by everything else is really, what dictates. I think the other thing to also remember is that company policies that vary the terms to the benefit of the employee do come into play as well. We have been in situations where we've discovered that companies had agreed on different circumstances to do things like pay 2 to 3 times the severance amounts that were the minimum severance amounts which were due to the employee, and it was done in a particular circumstance. However, it was deemed that it applied to all subsequent terminations, so that entitlements really were enhanced by that. So, concept of vested rights and constructive discharge, demonstrable evidence to terminate. Obviously, this can be operational in terms of the fact that you have circumstances that the company's survival is threatened, or you're really considering sort of the viability of maintaining yourself in the different countries. But you have to follow a process. There are legal requirements in terms of providing notice, going through notice periods. Actions can be individual or collective. Obviously, when you're talking about workforce reductions or reductions in force, they're collective. If you're talking about short-time work or temporary furloughs, they're collective. As we discussed in South America and in some European countries, there have to be court applications done. Brazil has very stringent requirements in terms of submitting and getting approval for anything to do with workforce reductions and terminations prior to engaging with the employee. And companies that are really claiming to be in financial distress and really have to do something about that can have their financial scrutiny, can have their operational justification scrutinized. And if it's deemed that it was inadequate, then the employee will be entitled to more consideration as a result of that in terms of severance pay and notice periods. Kim, do you have any other comments on this?
I think my main comment is the notice periods that we have, certainly in the European countries, are so much longer than people are perhaps used to. Notice periods can really vary here from 1 week up until about 3 months, and someone can automatically acquire 3 months notice from the moment they've passed their probation period. So the other one that I have really seen this week is, from an employee's perspective, is much more along the lines of they can understand that their employer is in trouble, but employees, obviously, the moment you start speaking to them about this stuff, start to panic. And what can start off as what appears to be quite a gentle conversation can very quickly go, south when people, feel like they're pointing out to you, well, you still have to pay me my notice, you still have to pay me my severance. And of course, from a commercial side, that's very difficult when you're thinking, I don't actually, know if we're going to have the money in order to go through with this. It is very, very difficult. I am now just going to talk over certain local labour laws, notice periods, minimum redundancy and severance payments. Andrew has discussed this, but I think the one thing to bear in mind, and I did just say this on the previous slide, is the current situation with COVID doesn't make someone's employment contract null and void. And you can have discussions with an employee, etc., but ultimately you cannot unilaterally impose on someone what the situation is. And also at this point, any sort of precedent in a company in regards to what notice periods you have perhaps agreed as company policy, which are in documents. So whether some companies have previously been offering a month's salary for each year of service, all of that stuff will come into play. The one consideration to very much point out in regards to the notifications, time periods, and the actual contractual notice period, a lot of the time in employment contracts, it will stipulate, you are entitled to 2 months, 3 months, whatever amount notice in regards to termination. That also doesn't take into account the due process that must be followed and any sort of enhanced payments that would be due. So this is what Andrew was saying in regards to any sort of CBA considerations. The requirements do vary wildly from each country, and it's not just based on someone's individual employment contract. It can also be the number of employees you have in a country, and certain countries will also take into account the economic circumstances that you have in other countries. So you may not be able to say, oh, well, we only need to do this in this country, because it really just it varies so much depending on which country you're actually looking at. I think at the moment, having watched this crisis unfold from an employment side, and none of us have seen anything like this, even back to the previous recession. If you on the side of caution at the moment and have the cash flow to do so, then we don't know when everything is going to more likely return to normal. And the last thing I would want to see clients do would be to jump into a redundancy program, see, all the notifications, the paperwork that you have to go through in order to do that. And then hopefully, fingers crossed, that when everyone is able to return to work in however many, few weeks, months, however long that will be, people obviously then having that very bad will towards their employer and thinking, oh my gosh, but the first thing they did when this happened was, they just wanted to make us redundant or lay us off. And as Andrew alluded to on the previous slide, for those who are perhaps more inexperienced, as it were, with some EMEA terminations, it is quite rare in Europe that any termination is not done through a mutual agreement. There's many reasons for this, and the main one is the ongoing risk of legal action. Different countries have different time periods whereby you can raise a claim. The UK is, you have a very short time period in which you can actually raise that claim with the arbitration bodies. But other countries, it doesn't just go from a couple of months, it's, a couple of years. So that's why mutual terminations are much more favoured, regardless of the cash flow that you have at the time and the time that may be needed for a mutual termination. To actually follow a full redundancy process in a country can actually take a number of weeks by the time you've sent letters to people, engaged with any works councils who you need to speak to, made any sort of applications, spoken to any council that you have within your companies. So it isn't, as I'd love to say it was simple, but Europe is never simple. And the payments that are made to employees, the statutory payment, yes, everything can be costed using what statutory payments are. Some countries, it is once, actually, to give an example, let's just go with Denmark, because once you're employed for 6 months, there's no recourse to huge amounts of redundancy pay, but you are entitled to 3 months' notice. So that's immediately a large cost that you have to bear in mind. Any other payments that are due, another example in France, there's outplacement support if you start making people redundant, and those schemes are ongoing. And yes, the social security system that is available in Europe is a lot more robust, but ultimately that's an entitlement that people would be looking at and kind of going, my normal salary wouldn't replicate that. And there's huge waiting times across all of Europe, because understandably at the moment people are looking into what are the claims that they can make. Any mutual agreement that you go through with an employee, or could negotiate on your behalf, I'm so loath to give figures because it just varies so much from country to country. But certainly if anyone does have any of their own advice that they want to perhaps speak in a bit more detail, I think to put a finger in the air and start giving numbers would be very, very difficult at this moment in time. Do you want to add to that, Andrew?
Sure, Kim. I think, as Kim said, I think that obviously mutual agreement, as we previously discussed, really you can certainly discuss the overall situation of the company, and how the crisis is affecting you, and specifically in terms of the things that you may have taken actions here in the States in terms of what's going on. I think that again, mutual agreements emphasize putting in writing anything specific to the employee, especially in the context of maybe considered varying the terms and conditions of employment. You should have to consider, and I think in some senses, mutual agreement and discussing things with personnel in European countries definitely the way to go. And whatever you do, if you do come to a mutual agreement, then make sure that you put it in writing and get it signed off by the employee before taking any actions in terms of making payments or, dictating garden leaves or notice periods. Again, in South America, a lot of it is governed by labor tribunals or labor courts, and there's a whole process there that you have to go through in terms of making things happen. So I think that you have to prepare and do everything, but the emphasis right now is obviously to, the governments over there are really emphasizing, to try and keep employees and look to get through this and look for the upside. And I think in terms of that, both from the government's perspective as well as the employees that you have, if you do intend to continue to do business in the European countries, there's very much a confidence and morale issue here in terms of what's going on. And it may obviously have implications in terms of, both the government's consideration of you in the future as you continue to do business with us there, as well as the employees, as well as even your customers. So very much, different social attitudes in terms of things going on. Okay, Talon, next slide. Kim, do you want to take this one?
Sure. Before starting any negotiation with any employees, I think the first consideration is to understand what type of contract employees have. There are different options in Europe, as there are indeed worldwide. So first one would be temporary contracts. That would be your either very short-term contracts, whether that's on a rolling ongoing basis, or whether that would be a 0 hours contract or a mini job, depending on the countries. Those sorts of employees will still have rights, even though there is a defined, perhaps, end date to those contracts, which does lead me more neatly onto fixed term employees. Fixed term employees in Europe are people who have been employed for a set period of time, and in order to not renew their contract, in many cases, you do have to give them written notice that their contract will not be renewed. In the best case scenario, on a fixed term contract, you are able to terminate the contract early. It depends on how it has been drafted. In some countries, if a fixed term contract has been offered, then to a large extent, an employer is actually obligated to pay to the end of that contract. So that situation can be difficult. There's certain countries where I've always recommended to employ people on fixed term contracts, just because of the nature of the employment law in that country. Any sort of indefinite contract, so they have different names, whether you call it an indefinite contract, a permanent contract. Certain countries have different acronyms that they use. If you are unable to continue to employ them due to the situation with COVID, then it will essentially either come down to a redundancy situation following that due process, a furlough if that is permitted in that country, or a mutual termination. They are very much the only options. The situation with COVID, as I said earlier, that contract, even though it is an employment contract, does still remain intact. And, if an employer is unable to pay salary, or is unable to meet their minimum obligations and doesn't, end up going through a mutual termination process, then ultimately, I think, to be clear and to be frank, then it would end up with legal action being taken against you. It's a very, very stressful time. And I think certainly from a client side and also from an employee side, people are obviously very panicked and very upset. Certainly, as everyone listening to this webcast can appreciate, this this has essentially been everything that I've been looking at for the last 2 weeks, and it's very hard to work through with, you know, clients and employees who are going, where's my next money coming from? And that comes from both situations. But I think from just the legal perspective, that contract is still there. It does still have to be paid. And this goes back to the delayed side of things that we were talking about previously. Any of the changes that you make to contracts, then, I know I mentioned this earlier, but regardless of the duration of that contract, they still need to be agreed. Yes, it would be so much easier to be able to dismiss or lay off your temporary workers depending on the country. But if someone is in possession of a contract that has no end date or has a fixed end date that is however many months in the future, then that modification has to be agreed. But it would be very much on a country by country basis as to whether you can actually amend that contract. And again, this goes back to the fact that we're all hoping that this will be over shortly. So I would always urge caution with any sort of action with this, because, you know, do you want to jump and potentially then create a worse problem, you know, later down the line? Do you want to add more there, Andrew?
Yeah, I think a couple of points, and well said about obviously stressful times, and you know, obviously there's a lot of concerned employees out there when you're working in remote environments, you know, which really do not facilitate that communication and understanding what's happening in the headquarters and, you know, what the discussions are. It does create a lot of stress in terms of what's going on. And I think that there are two things here. One is that obviously the employment agreement is typically with your local legal entity. That legal entity has liability in the country that it is incorporated in, and those employment agreements do stand against that legal entity. So that, as Kim said, they don't go away. Those rights will exist. Even if the company is in a situation where it doesn't have the cash flow, you know, that the obligations are still going to accrue to, you know, the legal entity in that country, and allow action against that legal entity in that country. So from the one perspective, obviously the legal entity is providing some you know, legal distance from the corporate headquarters because it is in the country, but your ability to do business and those liabilities and those court cases are going to continue as you move forward. I think the other thing to remember in these circumstances, if you're a company that has taken advantage of you know, employing people through professional employment organizations or employer records, then the consideration there is that obviously the employees in those countries are not your employees. They're the employees of the PEO or the employer of record. They've entered into the employment agreement. The operational circumstances and personal circumstances affecting those employees are not considered to be aligned with your business because they're employed by the PEO, and it's up to the PEO to take action, if anything, with the employees. But the justification in terms of things like short-time work and temporary layoffs is a lot harder because they're not obviously specifically associated with your business. The PEO has to justify it, and you do have to consider in the PEO's case that you know, they again have to take action, whether it's individual or collectively, treating their workforce the same. So you may have employees with that PEO and have circumstances which you're trying to put into effect in terms of, you know, the overall circumstances of your corporation. However, really it's the PEO that you have to work with to take any actions, because they are not in the circumstance of being able to provide the same justifications as you do. Did you want to have any more comments on the PEO perspective, Kim?
Yes, I think the main one with the PEO is, as Andrew said, that relationship does become very intertwined, because you have an employee who is working for a client, but is, employed by a PEO. And I think my one main piece of guidance there is you absolutely have to work with the PEO provider for this, because there will be a number of contracts. It's not just the contract, that you sign with the PEO, it's the contract with the employee. And whilst I totally understand that clients would want to treat any employees on a PEO in the same way as their payrolled employees by, issuing letters and including them in communications, it is very difficult to do so, because ultimately they are not an employee of your entity. Also, from a PEO perspective, you, as Andrew mentioned there, treating employees on PEO fairly and equitably is quite difficult when you have a number of clients who perhaps are employed by the same entity, and the repercussions of, one client saying, this is what we want to do, and taking action, then immediately afterwards going, oh, okay, we've done this, or, another client saying that, it is very, very hard. Anyone who has any employees on a PEO who you are considering, the fact that you may not be able to pay, or you may need to make them redundant, or you're wishing to consider to furlough them, so that you're treating them the same as, your payroll employees, you have to work with the PEO provider, because ultimately, at best, you will be able to resolve it, and an employee would be able to be furloughed or would move on, or in worst case scenarios, then there could be, serious legal ramifications, not just for the end client, the PEO, but also the employee.
Yeah, and I think it's important to remember there that, again, it's mutual discussions, and it's mutual discussions that the PEO has to have with the employee, as opposed to the company. And the company needs to be very careful in terms of any communications, because it really, they're employees of the PEO, and it's up to the PEO to come to the mutual agreements and to have the discussions. The employee may understand that there are economic problems that the company is experiencing. However, in terms of the legal relationship with the PEO, and that's what governs. So it will cause issues to the PEO if there is any direct communications that, again, are varying the terms and conditions of employment, and how that may be represented by the employee. So obviously, to some extent, the legal liability is going to go to the PEO, but usually there's indemnification agreements between the PEO and the client as it relates to how they've employed the person. So again, be careful in terms of how you do that. So the next slide is to talk about collective bargaining agreements, works councils, and unions. And I think, as we discussed earlier on in the webinar, collective bargaining agreements, works councils, and unions can vary the terms and conditions of the original employment agreement, often to the benefit of the employee. So I think that the thing to remember, and collective bargaining agreements are very prevalent in Europe. Then they can apply in South America and Asia as well. And they can be either industry-wide. For instance, in France, when you incorporate a legal entity, they actually require you to elect for a particular collective bargaining agreement, or they can be, company specific. But usually they do affect industries, or they do affect classes of workers in terms of what their entitlements are. In the collective bargaining agreements, it does discuss items such as work rules, entitles to holidays, vacation, leaves, benefits, statutory and supplemental benefit entitlements, that you have to put in place. So again, it varies and typically enhances the terms and conditions of employment of the employees, and also does usually address statutory severance pay or redundancy pay, and sets the minimum. So in these circumstances, it does modify it. It really has to be addressed in terms of any situation where you're planning even the short-time work or the temporary layoffs, as well as potentially terminating employees. So those variations need to be taken account in terms of what's going on. Unions, and this is more prevalent, I would say, in South America, and then to some extent in Asia and in Europe. But again, union representation, unions can be company specific or be industry specific. They often have very strict rules again that do modify the terms and conditions of employment, require consultation and agreements with the unions in terms of actions that you may be taking. And again, often this can be, very simple, changes to terms and conditions of employment as it relates to, vacation leaves, benefits, anything that could be deemed to be, a change that could be deemed, willful in terms of forcing someone to leave the company and be constructive discharge. So there's a whole consultation process. It does depend on obviously if you are unionized and who you consult with, in terms of what goes on there. More typically in Europe, we do have works councils as well that govern particular industries. It does usually depend on the number of employees that you have and whether the employees have can either elect their own works council or be subject to being able to join an existing works council. And there is a process there in terms of what goes on and what you're entitled to. I think the other thing to remember when we're talking about collective bargaining agreements, works councils and unions as well, is that, especially when it comes to the things like the, severance termination processes or, what could consider to be constructive discharge, the rules do vary in each country, the labor laws and the entitlements. You are in a situation where if you have a certain number of employees and you are going through that type of process, that you are forced to go through consultation periods. Often the employees can elect representatives to, that can represent them. And there is a whole process in terms of the representation and consultation process, and you cannot take any action until that has all been agreed. And in some countries, they even require you, like the UK, that you actually have to hire an attorney for the employee to consult with them in terms of what their rights are to make sure that they're not disadvantaged. So very important from that perspective. Kim, do you have any other comments on that?
I think my main comment on unions in Europe is an employer doesn't need to recognise a union for an employee to be represented by a union. Membership is very much based on an individual basis, and a lot of countries will, when you're having these meetings, allow you to bring a trade union and representative with you. So it's just one thing to bear in mind. Plus, with a lot of the notification meetings, some countries do have the requirement that it is done in person. I don't quite know how that one is going to work with the COVID impact, but the legal requirement is still there. With collective bargaining agreements, I think my main consideration with collective bargaining agreements is just understanding that certainly most of them would allow different categorizations of employees. So you could have employees who are entitled to different notice periods depending on their job level. So someone who is more junior may be entitled to less severance than someone who is more senior, but you may not even see this in their contract. It will very much say just, essentially refer to the CBA. And works councils, again, any advice there is always, if an employer or client is large enough to have a works council that is in place, it is very much trying to maintain that relationship, because you may not be able to proceed any further unless you have works council agreement.
We want to thank our panelists for their time today. Thank you, Andrew, and thank you, Kim, for your time. We did have a few questions that came through during the webinar that we wanted to get to. So let me read those off. So the first one was, how are local labor laws affected, and what employment protection is provided internationally?
I'll answer that one. How are local labour laws affected? To some extent at the moment, they're not. There's been no suspension of employment law internationally in countries. There are government measures that are essentially there to assist and support employers, but there is a waiting period on those. So nothing has actually changed labour law wise that I have seen in regards to making redundancies any easier. If anything, I would say justifying redundancies at this moment in time, with the level of quite unprecedented economic support that's being put in place in Europe, it would be quite hard to justify redundancy over a furlough if that is permitted in that country. And what employment protection is provided internationally, a lot is the honest answer. Realistically, you are going to be paying a notice period, a severance payment, and any sort of indemnity if you have to terminate someone and their contract as part of this worldwide situation. It's a very hard one to balance from a commercial side as to the amounts that you will have to pay to the employee. As Andrew said earlier, the local entity will still be liable. And if due process isn't followed, then that entity will be potentially challenged.
All right, thank you, Kim. So the next question, we'll take a couple more questions, and then we'll end the webinar because we are running out of time here. But the next question that we had was, what loans are available for small businesses during the COVID-19 crisis?
Yes, Alan. So many countries have approved, as we have here in the US, small business loans to companies. The mechanics, as we have here in the States, are still in process in terms of applying for those loans and the entitlements in terms of what you can do with those loans. Many of the countries are making provision in the loans that if the loans are being used to offset labor costs specifically, that they may be forgiven. And I say maybe, it's specific in legislation to say that labor costs would be forgiven, but it's not specific in terms of what those labor costs consist of and in justifying them. But many countries have approved packages to provide to small and even medium-sized businesses and to do that. And there is a whole process in place to make that happen.
Okay, great. Thanks, Andrew. And then the last question that we'll cover right now is, please discuss the impact of business loans and tax exemptions versus furloughs.
So I think in summarizing, obviously you have the small business loans, and you have a lot of the extension of cash to companies to try and stay in business, and the right to offset specifically labor costs and not having to repay those loans. But because a lot of the legislation is still in process and the mechanics are still in process, that it is changing on a day by day, if not hourly basis. A lot of the countries have put in deferrals of taxes at the moment, so be they payroll taxes or VAT, GST, HST, and so deferral of payments. There's not a I think there's been some discussion of tax holidays, but there hasn't been anything specific. I think that right now, the emphasis of the government is around trying to help companies preserve cash flow and then providing them with either the ability to go to the temporary layoffs or the short-time work, or basically take the loans. So that's the way that they see helping companies with liquidity to stay in business. But it's not really been focused on alleviating them of having to pay taxes at this time. It's more of the former.
Great, thanks, Andrew. And we've run out of time. We did have some other questions come in that we were not able to answer, so we will be sending out responses to those questions to the individuals who have sent those in. We want to thank our panelists for their time today. Thank you, Andrew, and thank you, Kim, for your time. And again, if you have any questions, we encourage you to send those over to info@globalupside.com, or you can call us directly on our phone number listed here. Just as a reminder, we will be sending out a copy of the webinar with a copy of the slide deck to all those who have registered for the webinar. And we want to thank everybody for arriving and listening in, and hope everyone is staying safe and well. And again, during these hard times, we hope that this information has been helpful and encourage you to reach out with any questions that you have. Thank you.